on the age of the victim, and they stated that prosecution did not prove this ingredient beyond reasonable doubt. My lord, on the evidence on record, it shows that court found that the victim is of a tender age, and it went on to carry out a via dia. My lord, a via dia wouldn't have been conducted if court did not observe the fact that the child or the victim, a one Nabkalu that is not of tender age. The child herself or the victim, my lord, went on to say that she doesn't know when she celebrates her birthday, which is on record, but she was told by the father that she is 12 years old. My lord, even prosecution witness number 3, the doctor who carried out the examination, proved that this is a child of 10 years, that she is 12 years. My lord, the authorities, case law has it, and especially the Uganda versus Abdallah Salim, criminal case number 4 of 2016, which has been availed to you, my lord, goes on ahead that the age of the victim can be proved by other means, like the parents, when a medical examination is carried out, or even common sense assessments can also be involved to determine the age of the victim. My lord, I pray that the case law is respected, depending on the evidence that has been adduced, and we so submit that the ingredients of age, that the fact of the age that the victim at the time of the commission of the crime was of 12 years, and that the prosecution has adduced sufficient evidence to prove the same. My lord, the defense in their submission stated that even the sexual act being performed was not proved beyond reasonable doubt. My lord, during cross-examination, my co-counsel, Mwangizi Norman, tendered in the statement of the accused, where in that statement, the accused accepted the fact that he had sexual intercourse with the victim, much as he alleged that the victim told him that she was of 18 years and above. And with the medical reports as well, my lord, of PW3, he went on to find that the hymen of the victim was ruptured, and he went on ahead to testify that it was the first time that this child was involved in such acts. The grudges that were found on the victim's body as well, my lord, prove that the sexual act was performed on the victim, and there is no way that it should, and there is no way coincidences could come in that the night the accused was arrested, and the night that the accused was arrested, in the same circumstances, is the same day that probably another person committed this on the victim. My lord, the defense still submitted that it is not the accused that participated or performed the sexual act on the accused. And they went on to state that we did not, that prosecution failed to place the accused at the scene of the crime. My lord, in examination in chief of the defense side, the accused testified that he went to Mr. Willie Franco's place around the evening hours. My lord, still in cross-examination, the accused admitted that he was at Mr. Willie Franco's home, much as he alleged that he left the place earlier on. And the prosecution, my lord, adduced evidence that it was Willie, if I may rephrase, that it was the accused that committed this sexual act. My lord, the defense alleged that the circumstances of identification were not favorable for the victim or the prosecution witness, number two, a one Willie Franco, to identify the accused. My lord, my question would be, is that how come that the accused was able to identify Willie Franco as among the people that arrested him if there was no sufficient light in the circumstances? Because during cross-examination, he said that he was able to identify the accused. He was able to identify Mr. Willie Franco as among the people that arrested him. My lord, the defense relied on the authority of Uganda versus Abdallah, Abdallah Nablede versus Uganda. My lord, I'm relying on the same where it was held, and the copy has been provided to you. Where it was held, that's where a person is familiar with the accused, even if the lighting is not enough, this person can fully identify the accused. My lord, let's look at the evidence adduced on record. The time the accused spent telling the victim that let's go behind the kitchen, asking about the whereabouts of the father, was enough time to fully identify the accused. And the defense, my lord, also submitted that the accused does not fall among the people that may be over authority of the child or over the victim. My lord, the defense defined a person of authority using the case of Uganda versus Abdallah Nabil Salim in isolation. This case goes on to define a person of authority to still mean a person who has been placed my lord, if I may rephrase, as a person that has any responsibility, any person who has been placed in a position of supervision or welfare of the child. My lord, this case, if I may briefly give the facts, it involved the teacher who used to teach this girl in the case, and that means this person was placed as a person of responsibility over the child. My lord, in the same manner, the accused is looked at as a person in authority because he is a secretary for defense. He is a person who carries on security duties. And my Lord, if, as I had submitted, that if the adults of the society do respect this man, how about a child of 10 years, my Lord? My Lord, in our conclusion, we find that the accused is a person of security because he has been, his role is to defend as he stated. And my Lord, we pray that court finds that prosecution has proved its case beyond reasonable doubt and the accused be convicted as indicted. Much obliged.
My Lord, may it please the court invite no one for the prosecution. I'll just add only on the accused being the one who committed the offense. That is the only part I'm going to submit on. And in the case of Uganda versus Folwark, it was held that there should be credible, direct, or circumstantial evidence placing the accused at the scene of the crime as the perpetrator of the offense. So, on the issue of identification, which the defense was relying on the case of Abdul Nabulele and another, it was held also in that case, the factors for consideration of proper identification of light, length of time, commission of the offense, proximity and relationship between the identifier and the accused are important. However, in the Uganda versus Folwark, the case that I have given you, as regard familiarity, prior knowledge of the identity of the accused and duration of the incident are sufficient to show proper identification. Prior knowledge of the accused. According to the evidence, the statement of Bure Franco, who caught the accused laying on top of the victim, it corroborates the statement of the victim herself. There was sufficient lighting from the lamp, and the witness, Bure Franco, arrived at the scene of the crime and arrested the accused before handing him to the police, which clearly shows that there was close proximity between the accused and the witness. Further, the witness in terms of relationship was a neighbor and a village mate, as was stated by the testimony.